Deposition, on the other hand, is a lot more fun. You can lead your witness. You really should know what the answer is going to be to those questions. It's an old rule, but it's still a good one. You don't go and ask a question if you don't know what the answer is going to be, because it could very well, once it's out, stay out, and it's going to be hanging up in the air for you to face. Don't ask those questions you don't know the answers to. I prepare the outline of the issues that I want to discuss, and on the left-hand margin, I use all of the information that I've learned from either depositions or interrogatories, so I have my cross-reference ready on that examination. You can often prepare your testimony as cross by your discovery by simply going right straight through the questions that you already have the answers to by one form of your discovery or another. But make your point and stop. It's the rare witness that won't develop the court's sympathy as you continue to pound away, minute after minute, going over the same fact and hoping to get a better answer than you did the first time. The likelihood is that you're not going to do it. Judge, we often hear the problem of the judge finally saying to a witness or to the attorney, well, you've gone far enough, counsel. I really don't want to hear any more than that. Do you ever make that statement to litigants in your courtroom, Judge?
Well, I'd like to say I haven't, but I think there might be some transcripts that would dispute that. Yes, that occasionally does happen, and I think it's just as well, unless you are satisfied that you know something that hasn't yet been developed, that needs to be developed, and that the judge doesn't anticipate, unless that situation exists. I think you might just as well go along with the judge there. Lauren told us that reminded us again that there's a big distinction between jury trials and non-jury trials, and one of the biggest distinctions is in the fact that it's the judge and not the jury who will be listening to and weighing and evaluating the evidence. The jury in a jury trial is usually rather unsophisticated and excited, or at the very least rather interested in being in the novel situation of being in a courtroom, and so they will likely listen pretty attentively, even though the witnesses may give answers that are not responsive to questions, even though they may circumstantialize and ramble, but you won't often find a judge being very patient about that. And as a matter of fact, I have sometimes, I must confess, gone a little further than Lauren has said, and have told attorneys that I am having difficulty keeping my mind on the case because I'm getting so little information from the witnesses. I think that it's really very important that you, in a non-jury trial, even more important than in a jury case, that you prepare your client and your friendly witnesses by asserting to them as strongly as you possibly can the importance of being responsive to questions and stopping speaking after they have responded to the question, waiting for and listening to your next question. You've got to get their confidence and satisfy your client that you know what the case is about and you're going to be able to answer all the important questions, and they needn't try to blurt it all out when you first ask them their name. You're going to have a little bit of trouble with the judge one way or another, and the worst way is if he says nothing to you, but in fact starts thinking about last Saturday's golf game or next Saturday's football game. So it's important that you keep your witnesses particularly well prepared and in line in a non-jury case. Anything else, Lauren?
Finally, that as you're beginning to work down towards the trial, your notices to appear, if you're going to require those witnesses, must be prepared. Your subpoenas must be ready to go, and you must be geared up to go to trial. But as you know, the system in which we work doesn't really work that way. You're all ready to go to trial, and you know in your heart of hearts it's only the first time you've been called out to trial, and you know in the county that you're appearing in, you've got to be at least up there 3 times before you're ever going to get a courtroom. But unfortunately, you must be up for each of those events, because there's that chance, and likely though it might be, that you're actually going to get a courtroom the first time out. You can't wait and hope that you're going to prepare the case for trial the next time you are asked to come to trial. You might go that first time. The order of presentation of your testimony and your evidence is at its best one that progressively builds the issue in the case. Again, it doesn't quite work that way. The courts and counsel are again always ready to reasonably consider a motion to take a witness out of order as you're dealing with a schedule where that particular witness might have reserved 3 different days for the trial and they weren't called. So when they present to counsel an argument as to why they should be called out of order, you'll find courts generally very sympathetic. And that doesn't do a great deal for your orderly presentation. So you must always keep your eye on the bouncing ball. You're trying to convey certain facts to the judge. You're trying to make the judge understand what it is that you want to convey and what relief you're seeking from the court. The best order of presentation is one that leads the court to the inescapable conclusions that you want the court to reach.
Narrowing the issues is one of the keys to producing a short cause, and a pretrial conference is one of those keys. 17 years ago, pretrial conferences came into existence, and at that time they were made mandatory. It was thought by the Judicial Council that they would be effective in greatly shortening trials. Well, they didn't succeed in that. Some think because of opposition by the bar and because they weren't given a really good test. But for whatever reason, pretrial conferences are now entirely discretionary, and the parties either party can indicate an interest in having a pretrial conference by checking the appropriate box in the at-issue memorandum. The Rule 208, which deals with pretrial conferences, also provides that the court may, in its discretion, order a pretrial conference, but in my experience, it's never done unless at least one of the parties thinks that it would be useful. The prerequisites for a pretrial conference are that discovery be completed and that each attorney, quote, shall have a thorough knowledge of the case, be prepared to discuss it, and to make stipulations or admissions where appropriate. There must also have been a conference in person or by correspondence between counsel before the pretrial hearing. The parties must prepare for submission to the pretrial judge a joint written statement of the matters agreed on and a joint or separate statement of the factual and legal contentions raised by the remaining issues. The conference is generally held informally in chambers, and it won't be reported unless the parties request it. At the conference, the pleadings may be amended, simplification of factual and legal issues will be attempted, admissions of fact and stipulations for introduction of documents will be sought, settlement may be explored, and procedural matters may be considered and resolved. A trial date may also be assigned at that time. The conference will result in a pretrial conference order which becomes a part of the record and, where inconsistent with the pleadings, will control the future course of the case. That's pursuant to Rule 216. Now, I've dwelled on the subject of pretrial conferences because they can, as I said earlier, make a short cause out of a long one. But if you already know that you've got a short cause, it probably won't benefit you or your client or the case to take the time and effort of a pretrial conference. And the advantage of an early trial date may very well be diminished or even lost if the pretrial 60-day notice requirement results in any delay. There's no reason, though, that counsel can't communicate with each other without the intervention of the court to explore the possibility of stipulating the facts and issues and to the introduction of evidence, including the use of depositions and exhibits and the appointment and use of experts and the taking of judicial notice by the court. But one caveat, if you do reach informal agreement with opposing counsel on any of the issues, you ought to get it in writing. And if you don't do it by a formal stipulation, you ought to at least do it by a confirming letter. There are a few things that